Yes. Counsel, are you here already, or? Okay, who do you have?
Good afternoon, Your Honor. Jonathan Friedman. I'm here on behalf of Deborah Rogers, Judge. She's on the docket. I think she's the first one on the docket.
It says no paper. No, that's the recess.
It was a
Oh, they
recess.
sent them this
Oh.
morning, that's right. Sorry about that.
Hi, Miss Rogers.
Can I get? Oh, thank you. Appreciate that. All right, we're here on Deborah Rogers. Miss Rogers, good afternoon. You're here accused of grand theft auto and fraudulently uttering a false instrument. The court did find probable cause unless you have some argument to be made.
Judge, we agreed on this bond, myself and Don Tenbrook, so it is what it is, and her family and friends up in New Jersey are going to be posting that bond
Okay.
momentarily, so she'll be getting out.
Excellent. I think she was concerned and we didn't have the answer to that, so she wanted to wait for you to make sure. So the court does find probable cause, bond count one. State, you agree?
Well, I'm not aware, but I have no reason to doubt counsel.
Okay, 5,000 and 1,000, so a total of $6,000. Hopefully your family will post it soon.
Yeah, the
Your
only,
Honor, I'm sorry, I would just ask if you could, if it could be ordered, no victim contact, which I imagine shouldn't be a problem.
No victim contact is ordered.
sure, and just so the court knows, she's from New Jersey, so at some point she'll probably be going back to New Jersey. I've been retained privately,
You can
so
address that with
yeah.
division
that's fine.
at this
All right.
point.
Give me a call when you get out there, bro, okay?
Your Honor, the jail up in Pompano is called. I'd like you to call 3 consecutive cases out of turn if you could. One would be Mr. Merchant. He is on
Got it.
page 3. What's up? Hey. Whose phone number? No, she doesn't. She's getting out of jail. She can get it then. He's gone. Okay, bye.
Guess the volume doesn't go down. All right, who's the other one?
Mr. Mingo, who is on page 2 of the second look docket.
Oh, do you have that over there? All right, well, we'll have to remind me on that one then.
And the other is Mr. McDougal, who is somewhere.
Okay.
Also on the second look docket.
I don't see a
I
McDougal
don't
on there.
see him.
We don't have a McDougal on that docket. It's on yours?
Just so you know, I also gotta, in case you speak to the victim.
The clerk doesn't have it, apparently it doesn't exist. We will deal with that, I guess, as need be. All right, let's start with the first one then, and where am I going to, North Broward?
Yes, ma'am.
All right, let's do Ivy Merchant.
Merchant, come on in.
All right, just wanted to let you know. All right.
Ivy J. Merchant, you're accused of having a capias on a misdemeanor. It's an add charge of criminal mischief. The court does find probable cause. Bond is recommended in the amount of $25. State.
Your Honor, considering it's count 20, I'm not gonna ask for any modification.
All right. So, anything to add?
No, Your Honor, Mr.
All right,
McDougal.
bond in the
Mr.
matter-
Merchant's being held, no bond holds.
Okay, $25 on count 20, and your next court date will be September 6th. Good luck to you, sir.
Could you tell me anything about it? Because I've been arrested since I've been in jail for 9 months now.
Yeah, I read it originally. Steve, do you have that in front of you?
It's from an unserved summons.
Case number?
171957 MM10A. The probable cause affidavit's in Odyssey.
I know.
Okay.
It is alleged that on December 16, 2016, at approximately 1:40 hours, officer responded to Miramar Parkway in reference to a criminal mischief report. Officer Eisenberg advised that the Ivy Merchant threw a rock onto a windshield of a vehicle at the listed location, and you allegedly fled. They lost sight of you. Myself and other officers responded to the area. You were located. It should be noted that they had previously been there for a landlord dispute. The victim stated to the officer that he wished to prosecute. The damage to his vehicle is estimated to be in the approximate range of $400. That is the allegations.
All right, thank you.
You're very welcome.
Have a good day.
You as
The
well.
next one I'll bring in is Mr. Mingo, since you have the paperwork on him. Come on, Mingo.
Mr. Mingo, on page 2, it is a trespass to conveyance second look. What's the bond on that?
I believe the bond's $100, Your Honor.
Okay.
If I recall, he appeared before Judge Fry, last Friday morning. We can get you, actually, I don't know if the PC's an Odyssey or not
That's okay.
yet.
PC, it's just, it's not reset for PC, it's just because of his
It's a
bond.
it's a second look, Your Honor.
All right, Mr. Mingo, does you have a place to go, an address? Who do you live with, if or anybody?
I have a hotel that I go to.
You have a hotel do you go to? Do you still have that hotel?
Yes, I have. It's called Atlantic Inn. It's over here. It's not too far from here.
Okay. Is that where you'd be going if I let you out of custody?
Exactly. That's exactly where I'll be going.
And you have the means to continue to pay for that hotel if I let you out of custody?
With my social security check, yes, ma'am.
All right. State any objection to releasing them to pretrial upon verification? I don't know, can you verify that address?
That's the thing. I mean,
All right, I'm gonna do what I did last time. He has to report to pretrial within 24 hours of his release.
If pretrial want to talk to him, if they can, I'll have them talk, I'll have them, call now.
All right, pretrial release. Report to pretrial within 24 hours of his release to confirm the address where he'll be staying.
So what does that mean about today, Your Honor? Will I be
That
going
means
today?
that means that I'm releasing you to the supervision of pretrial release, but you have to report to them when? What's today? Today is Wednesday.
Tuesday.
So you need to report to the pretrial office by 12 o'clock noon tomorrow and bring in proof that where you're staying, okay? So
And I
that,
will give him a map right now of where it is, so he has it.
all right, good luck to you, Mr. Mango.
Thank you.
Hold on, don't leave yet.
I'm just curious, if he's unable to provide an address, then what?
Well, if he has no place to live, that'll be a violation. So I need an address where you leave, Mr. Mingo, or put him back in. I don't know what to tell you. But he's telling me he has a place to live. I'm giving them opportunity to provide it. Otherwise, if he's not gonna do that, tell me now and we'll consider some other alternative.
Well, the person that handles my money is my sister.
Uh-huh.
You know, so
All right, do you have a phone number for your sister? Maybe we can call her and verify that she's willing to rent you this room.
okay, 754.
Okay? Pretrial, you getting that?
Or if you can ask her just to loan me about $100 until I pay her back, because my check comes on the 3rd of every month.
I'm sure she's gonna be.
And I don't know if I have any money left over. That's
Okay.
the reason why I was saying.
It's sounding weaker and weaker. Okay. Mr. Mingo. When's your check come in? At the beginning of the month?
Yeah, on the 3rd.
Okay. Who's he in front of? Is it assigned yet?
I'm sure it is. Judge Gottlieb.
All right. All right, Mr. Mingo, this is what I'm gonna do. Pretrial, can I do this? You tell me, because it's your program. Can I just order him to report to pretrial weekly, regardless of where he lives?
Ooh, that would be nice.
I wouldn't say too much else right now, Mr. Mingo. Just kind
Okay,
of.
I'm sorry.
And that way, if he
Oh,
fails
it's
to,
all right, man. It's all right.
and that way, if he
I'm
fails to,
military too, man.
I appreciate your service. And that way, if he doesn't appear, you can issue a violation.
So he'll have to appear at least once a week in person?
Yes.
Okay.
All right, I'm gonna order you to release to pretrial release. You'll have to appear at least once a week in person when they tell you to. The first appearance must be tomorrow by 12 noon. Thereafter, they'll tell you when to come, and you must appear at that time. And that way, we can make sure that you're informed of your next court date, okay?
Thank you.
Take this
Yes.
piece of paper.
ROR pretrial, weekly
Good
reporting.
luck, man.
Thank you.
Last one is Mr. McDougal.
All right, that one I don't have any information on. So, do you guys want to reset it for tomorrow, or do someone want to look it up? I'm not quite sure.
Sure.
Okay, tomorrow sounds great to Mr. Reedy. All right, reset Mr. McDougal for tomorrow since we don't have him on our docket for today.
Sounds good to me.
Thank you.
Thank you, Your Honor. I really appreciate that.
No problem. Have a good day.
You too.
All right, back to Beatrice Holmes.
Ms. Holmes is approaching, Judge. She's here at Maine.
Good afternoon, Ms. Holmes. You're accused of grand theft and uttering a fraudulent or false instrument. The court does find probable cause. State.
Your Honor, Ms. Holmes' priors include 2016 uttering a forged instrument and 2012 grand theft. I'm asking that the convenience bonds are kept in place.
Defense.
Judge, she told me that she contacted her mother. She was hoping her mother would have already posted her bond. Could confinement status verify if her bond's already been posted?
They're checking. No, not yet. Not yet.
Judge, in the alternative, if the mom hasn't posted the bond yet, there may be some sort of financial difficulty. And speaking with Ms. Holmes, I believe the date of incident on this offense was approximately 9 months ago. Since then, Your Honor, she's been placed on probation. She's actually on probation now. This offense happened before she was placed on probation. She's on felony probation. She's being supervised by her probation officer, Miss Fraticelli. Judge, since being placed on probation, she's actually gone to school. She's graduated from an institute called OIA of South Florida, which helps her obtain a trade. Right now, she's looking for employment in that trade. She's a single mother of 2 children, ages 4 and 1. Right now, her mother is helping her take care of her kids. Considering she's being supervised at this time on a felony probation case, Judge, I'd ask you at this time to entertain ROR on the 2 offenses we have before you.
State, you concur that this occurred prior to her being placed on probation?
Yes.
All right. I'm inclined to place her on pretrial release. Any objections, since she's on felony probation, so she violates? The consequences are gonna be greater.
Okay.
Pretrial release on counts 1 and 2, standard. Thank you. Ashanti Deshawn Coombe.
That's North Broward, Your Honor. She's a medical reset again.
Okay, thank you.
All right, North Broward's completed.
Thank you very much. Have a great day.
You're welcome.
Kelvin
You
Petit Frere? Ferrer?
Mr. Petty Frere is here present at Maine, Judge.
Ms. Frere, you're here today on a capias for a misdemeanor for possession of cannabis. The court does find probable cause. You also have a writ of arrest with a purge of $446. State regarding the misdemeanor.
Yes, Your Honor.
Any objection to $250?
No.
Defense, any comments on the $250?
Judge, Mr. Petty Frere is inquiring if Your Honor would consider resolving this case today.
I read it, but I have to go back and look at it again. Hold on, give me a second.
It's possession of cannabis, I believe.
In light of the allegations in the probable cause affidavit, I'm not inclined to resolve it today.
Judge, respectfully, then, would you, it's a cannabis charge. He's right now going to Florida Career College. He's studying to get his HVAC license. On count 2, he's going to contact his family. All of his financial resources are going to go towards paying the child support of $446 on count 2. That's why I wanted to try and see if on count 1 we could somehow resolve it so that his family wouldn't have to go ahead and put up the bond money on the cannabis charge. Would you consider then an R on count 1, so therefore all the money could go towards child support?
I would add, Judge, that he was cooperative and did admit that he was wrong with what he did.
So noted, however, in light of the number of baggies in his possession, the court would be more comfortable if he were on pretrial supervision.
Well, I can also advise the court, and I checked, Mr. Pettifrere has been arrested multiple times for failing to appear in court.
Okay, well, that's a concern as well. At this point, in light of his failure to appear, I don't think he's a good candidate for pretrial release, so therefore, I think the bond is fair, $250. Javon Philip Lowe.
I've been advised he bonded, Judge.
All right, court finds, probable cause on both counts, it's bond amount of $500 and $1,500. Calford Cleveland Lewis.
Mr. Lewis is approaching. Come on up, Mr. Lewis.
Mr. Lewis, you're here today for the charge of driving while your license is suspended with knowledge, and also there is a writ of your arrest with a purge of $414. At this time, the court finds probable cause. Any objection to $100 state?
No, Judge.
Defense, what say you?
Judge, Mr. Lewis is asking if you would consider R1 count 1 so then his family could post the purge amount, $414 on count 2. He's been in custody since Sunday, I believe.
Let me look at his record. I have no objection. I'll RR him.
Thank you, Judge.
Kevon Michael Mowat.
Mr. Mowat is approaching, Judge. He declined the service to the public defender.
All right, Mr. Mowat, you do have the right to be represented by counsel at this time. Do you wish time to consult with a private attorney? Or do you wish to represent yourself? Or do you want me to appoint the public defender's office to represent you?
I mean, you can point the public defender office to represent me.
Okay, Mr. Hector Romero, come on back up. Go tell the attorney that he's back on.
No, there's more there.
All right, just to let you know, Mr. Mowat, I'm appointing the public defender's office at his request. You are here today because you're accused of possession of cannabis less than 20 grams, driving while your license is suspended with knowledge. You also have a probation violation for two different, no, for one, I think it's the same case. For one case. And you'll be held no bond on the violation of probation. The added charges of possession of cannabis and driving while your license is suspended. The court does find probable cause. What say you state regarding counts 1 and 2?
I'm not
Judge, before we get to that, I'm advised that Mr. Mowat has advised our office that he has retained private counsel on this case.
Mr.
Michael
Mowat,
Morat.
do we have any notice of appearance on Mr. Mowat's case?
I'll check, Judge. Did he say who his attorney was?
Michael Murat?
It's Michael Myers. That, Your Honor, that's who represented.
Him on the
Oh,
probation
wait, one
case?
moment, Your Honor.
No. Who
Okay.
represented me on the probation case is Johnny McCrae.
Oh, very nice.
But I have
Okay.
a good lawyer now.
Okay. Mr. Meyer filed a notice of appearance on his probation case.
Okay.
And that was filed today.
So would you, well, you're being held to a bond on the probation case, so that one is, you have to see the judge on. I'll appoint the public defender's office only for the limited purpose of the new charges.
Judge, I'll have him afterwards fill out the financial affidavit stuff.
All right.
Because he
And,
still has to fill out the paperwork and everything, be charged and everything.
all right, well, do you want to waive the public defender's fee, representations in order not to pay the $50 application fee?
Yeah, waive it.
Okay, so at this time, you want to represent yourself on the possession of cannabis? And the driving while license is suspended?
No, I rather my lawyer do that.
Okay, so do you want me to reset this then until tomorrow so he can be here?
Yeah. Yes.
Okay, reset it to tomorrow. Good luck to you, sir. Philip Lane.
Mr. Lane, come on up, please.
He's approaching, Judge. He's here, me.
Mr. Lane, you're here today for a traffic violation for disobeying a stop sign, driving while your license is suspended with knowledge, possession of THC, and possession of cocaine. And your bond is being posted as we speak, so you'll be out shortly. Court finds probable cause on all charges, bond in the amount of $750, $1,000, and $1,000. Richard Patrick Lucelle. Mr. Lucelle, you're here today accused of possession of cannabis less than 20 grams. You also have an attached registration license plate not assigned, which is also a violation of misdemeanor, and then a probation violation where you'll be held no bond until you see your judge. The court finds probable cause on count 1 and 3. What say you state regarding bond?
He's got a hold, Your Honor. I'm not asking for any modification.
All right. All right. What say you, counsel? Bonds recommended to be 100 on count 1 and no charge on count 3.
Yeah, she asked me about the cannabis.
Judge, at this time,
I mean,
he's
that's,
being held no bond
right.
right now on count 2. He's just looking to see if he can get into court right away to try and see if the state's gonna file these charges or not, so he can fight it. I was trying to explain to him
I don't know that you're gonna get in that any quicker, but you can always set a hearing in front of your assigned judge once it's filed. If you can't afford the $100.
Oh, that was
Of course, just keep in mind, sir, that everything you say is being recorded and can and will be used against you at this hearing or any future hearing. You do have the right to remain silent. It might be in your best, it might be right in your best interest to relay the information to your attorney, have him speak on your behalf. But if you wish to talk to me directly, you certainly can.
The reason though I was asking for some type of expedited motion is because I am the head coach of Little Haiti Patriots. And our city, we just had Tekosi, which is our inner rival. Basically, they broke up, and all their players came to my team yesterday. And so that's why I was asking to see if I can get, something in front of the judge early because we have a game on Saturday. And I'm the head coach. I'm responsible for 32 kids. And that's volunteer work. I don't get paid for it, but I've been the head coach for 5 years.
Can we get him a date on the?
But here's the thing. And I'll
It's
just
kind of like
put it
already
out there.
Tuesday.
His probation is from another state.
Oh,
So that hold's gonna be in place until this local case is resolved one way or the other. And the hold out of the other state is a probation. So I would imagine, and he'll be advised by his attorney, whoever it may
Yeah.
be, that it's not as simple as just resolving it when you go to court.
it's unlikely that the probation hold will be resolved by your game on Wednesday. You might want to let someone know that they're going to need a substitute coach. You may be able to resolve the possession of cannabis and the attached registration in a timely manner, but that's not what's keeping you in custody. So
And even then,
once that's resolved, you'd still have to decide what the other state is going to do on the probation, if they're going to extradite you or not.
well, and even then, and I'm sure it'll be advised, resolving this case could result in an automatic
Correct, and
violation
resolving
of-
this case can resolve it all. You're gonna have to, you'd be better off seeing your assign, you may be better off waiting until the charges are filed and seeing your assigned judge. Your attorney can give you the advice on what's in your best interest, but at this time, bonds in the amount of $100 on count 1, court will ROR on count 3. Good luck to you, sir.
Good luck. I was sitting in my car.
I know. The probation violation. Jason Emmanuel Patterson.
Mr. Patterson, come on up, please.
Mr. Patterson, you're here today on counts 1 through 14 for possession of a weapon or ammunition by a convicted felon. Count 15 is possession of cannabis less than 20 grams, and count 16 is attached registration or license plate not assigned to the vehicle that you're allegedly in. The court does find probable cause in counts 1 through 14, 15, and 16. State. What's your
Yeah.
recommendation? Is
And-
it 17? Did I miss one? Oh, there's another one? Oh, yeah, okay, that too.
And just to advise the court, normally, and I know if I know Mr. Reedy will, normally what we do on the possessions of weapon or ammunition, usually bonds can be set, even though there's PC, will be set on the first two counts, one for the weapon, one for the ammunition, with just RORs on the remaining counts, since it's a bit redundant for each separate piece of ammunition.
Understood.
Your Honor, I can advise the court, and on a pretrial, if you can confirm this for me, I do see that Mr. Patterson has a federal prior possession of cocaine with intent. He was sentenced to 3 years in federal prison, and that was under the name Miguel Patterson. I do show under his FCIC, or I'm sorry, his NCIC, that he's used multiple dates of birth, multiple social security numbers in the past, also referencing the ag assault, prior conviction for aggravated assault that is referenced in the probable cause affidavit, Your Honor. Your Honor, I'm going to be requesting bond in the amount of $7,500 on count 1, $2,500 on 2, and just for any of the other charges that bonds will be set on, I would just ask that the convenience bonds be kept in place.
Okay. What say you, defense?
Judge, in speaking with Mr. Patterson, he's been residing in South Florida his whole life. He's 37 years old. He works at a body shop in Hollywood. He's a body guy. He's been employed with the same company for about a year. His salary, I guess, fluctuates depending on how many customers they have. He's currently living in Miami. He's been residing, him and his mother have been residing in the same residence in Miami for over 15 years. His mom is the only person that's probably going to help post his bond. But she's on disability, and I know she recently, from what Mr. Patterson advised me, she suffered a stroke. He's helping her through this, and I believe the prior that Mr. Lender was talking about, I believe it was over 10 years ago. Judge, I'd be respectfully asking you to consider on count 1 a $5,000 bond, and on count 2, I'd be asking you for a $1,500 bond. And I'd ask you to keep the standard bonds in place for 16, 17, 15.
Court's gonna set bond on count 1 in the amount of $7,500, on count 2 in the amount of $7,500, ROR on all other counts. $75 on each. Giancarlo Perez.
Mr. Perez is here approaching, Judge. He declined the service as a public defender.
All right, Mr. Perez, you do have a right to be represented by an attorney. With this time, are you going to be hiring a private attorney, or do you wish to represent yourself?
I'm going to be hiring a private one.
Do you wish me to reset this hearing for tomorrow morning, where you'll have an opportunity to have your private attorney here to represent your interests?
Yes.
Okay, I will do that. Tomorrow afternoon? All right, it'll be tomorrow afternoon. Siddiqui Clark?
He's here in Maine.
Mr. Clark, you're here today because the state has filed an information changing the charge from which you're originally before the court to murder dangerous to prey without premeditation. State, what do you recommend?
Your Honor, I'm going to be asking that he be kept on the no bond hold that Judge Fry ordered when he had his first appearance originally on murder 1 charges, based on the same affidavit that I provided the court. I would also note from what I see on Odyssey, Mr. Clark was arraigned by Judge Scheer this morning.
Oh, he was already arraigned, okay. Defense, what say you?
Honor, I believe that Mr. Clark is also being held on some violation of probation no bond holds. So we would reserve any argument regarding proof evident presumption great until his attorney, Mr. Jose Reyes, can make those arguments in front of Judge Scheer.
Well, I have to make a determination today unless you want to have Judge, I'm not sure, you're asking me to postpone the Dawn determination to Judge Shear?
Well, Your Honor, what I think I can do, what I think you can do, Your Honor, especially if Mr. Reedy has no objection, is I think you can adopt, even though it was for a higher charge, you could adopt Judge Fry's previous decision at his first appearance. And then, obviously, the Public Defender's Office, if they so choose, could file for an evidentiary Arthur hearing before Judge Shearer.
Well, I'm not sure if were you asking for, yeah, I guess at this point, are you asking for me to postpone the Preston determination today? Or may I proceed and then without any prejudice to readdress this in front of Judge Shear?
In all honesty, Judge, if this was the only charge that he was facing, that
Correct.
might be a different situation.
Since
But he
already
has to go in front of Judge Shearer because of the no bond holds anyway. So
Correct.
I think it's
add one
really up
more.
to Mr. Reyes to decide, along with Mr. Clark, how to proceed from this point.
And that's why I suggested maybe, Your Honor, if you would just adopt Judge Fry's, then you're really not making a determination, you're just adopting his previous
All right,
determination.
since, based on the state's recommendation, I guess at this point, the court will just adopt Judge Fry's based on the fact that an information has been filed, and defer any future considerations to Judge Shear, who has all his other pending charges. No bond at this time remains in place.
Your Honor,
Okay, yes?
Conti, we have one reset from this morning.
Yes,
Sean Derval.
we do.
The conflict counsel.
Yes, can you bring Mr. Darival?
Sean, come.
Okay.
He's coming, Your Honor.
How you doing, Your Honor?
Hi, Mr. Darival. Good afternoon. Seeing you again. We're going to go ahead and proceed with the Public Defender's Office representing you because they were already appointed to represent you. They have not withdrawn from your representation yet. That determination is scheduled to be made by your assigned judge on a future date, which is already, I guess, it's already scheduled, correct? Or you already filed it?
Yeah, we filed, actually, you heard his motion to release yesterday.
Okay. So at this time, the Public Defender's Office will represent you if you're okay with that.
I believe he has his status scheduled
Okay.
shortly.
Right.
So-
You know, it seems to me that this is a matter best resolved in the division. If I'm understanding correctly, the information's been filed.
Yeah, all I'm gonna be asking the court to do, frankly, is, what happened was, on one of the counts, it was changed from, armed burglary to burglary of a structure.
All right, so it's
And-
been reduced.
And, yeah, and all the other counts have been, all the other counts before the court have been added. He's also being held no bond on an armed burglary. What I wanted to do, if you have no objection, Mr. Reedy, is just very quickly give a proffer to the judge what the circumstances are that led to the downfiling, and I was just gonna make a recommendation that I think's reasonable, considering he's also being held no bond on 3 counts.
But he's being held no bond on charges
He
that
is
are
being
not
held
before
no
us
bond on
today.
3 punishable by life counts.
Okay, so
for proof.
unrelated to this, he's being held regardless.
Well, no, it's, yes.
Okay. And then we have an additional 1, 2, 3, 4, 5, 6, 7, 8.
Yeah, it'll make a lot more sense once I
Okay,
advise
9,
the
10,
court.
11 KPS felony.
Your Honor,
add charges.
the allegations are that Mr. Darival and his co-defendants broke into a Bass Pro Shops. Over multiple occasions in the
Correct, I
same
read
night,
that, yeah.
they broke in and stole guns. The allegations are, on the first time they went in, they got scared off and didn't steal any guns. So that's why we downfiled that charge from armed burglary to just burglary. All the other ad charges are for the guns that were allegedly stolen. Your Honor, what I was gonna be recommending is a $5,000 bond on the burglary structure. He's still, and keep the other convenience bonds in place. He's still being held no bond regardless on 3 counts of armed burglary.
Okay. Defense, anything to add to that?
I don't think that's unreasonable, Judge. I think Mr. Durvell understands that our office is going to be withdrawing from representing him in the very near future, and he can take that issue up. I know there's a number of co-defendants involved in this case, so I don't know if it'll be a regional conflict counsel or someone
Or
else.
another one? All right, at this time, Mr. Durival, do you understand what's happening?
Yes, ma'am.
Okay, so on one of the burglary arm charges, they've reduced it to regular burglary, so I'm gonna go set the standard bond of $5,000, which is appropriate in light of your other charges and what you already have. And then the convenience bonds on counts 19 to 29 are $1,000, and the court has no objection to that being reviewed once you have your new counsel in front of the assigned judge. Good luck to you, sir.
Judge, is there any chance that I could fight this case on the outside?
Well, on this case, you're not being held no bond. Those cases are not before me.
It's all part of the same case, Your Honor.
But I don't have the no bond cases in front of me to readdress that situation. So at this point, you would have to address that with the assigned judge.
Yes, ma'am.
Good luck to you. All right, thank you. Kevin Mowat.
Yeah. Yeah.
So,
It was,
oh, okay, thank you. Okay,
well, Your Honor, it was part of the VOP that I believe you already ordered him to be held on that.
okay. So, was that the one who wanted the lawyer for tomorrow? I can't remember.
Oh, was it? Okay. Oh, okay. Oh, if that's,
Okay.
oh, then absolutely.
All right, so let's go to our dockets. So, Antonio Everett.
Mr. Everett is here present, Judge at Maine.
Okay, thank you. That was reset because?
It's a second look, Your Honor. This is on a battery. Just trying to find the,
Miss Christina, a pleasure to see you. Although I hear it's Mrs. now. I missed that one. All right, let me look that one up real quick. Definitive touch and touch. Punch and push. Okay.
and, Your Honor, his bond was kept at the convenience bond of $1,000. I believe that was done, I believe it's appropriate based on one, not only the aliases he's used in the past on the booking sheet that include Antoine Eady, Ralph Edwards, Ralph Everett, but also his criminal history. 2011, he was convicted of domestic violence battery, sentenced to 120 days county jail. 2010, resisting without violence, loitering or prowling. 09, he was convicted for battery. 09, he was convicted for battery and he violated probation. 07, he pled out a battery to disorderly conduct.
Okay. Defense.
Judge, in speaking to Mr. Everett, I did advise him that he will have his opportunity to fight this case in court. There's obviously always two sides to the story. But having said that, Judge, unfortunately he is homeless. He has no way of posting this monetary bond, but he does have a mailing address. What he's asking Your Honor to consider is potentially a pre-trial release. He would abide by any conditions you impose. If you order him to check in or report once a week, he will do that. He will be able to receive his notices in the mail to appear for his future court dates, but at this time financially, he's not in a position to post this monetary bond.
Well, at this point, counsel, due to his history of violence and this being another incident of violence and his unstable residence situation, which does not provide, and the fact that he's used aliases in the past, and I would only be, if I even considered it, I think he might be, I would consider a monitor, and I don't have the means to do that when he's unfortunately homeless. But I don't believe he's a good candidate for pretrial release without more intensive supervision in light of his aliases and his history of violence. So that request is denied.
Judge, in that case, if pretrial can verify with his cousin, if his cousin would allow him to reside at his residence, then the monitor would be possible. Would you consider it at that time?
I would consider it with you have to talk to the cousin, but I would consider a GPS monitor, but I would be considering a GPS monitor level 1.
Yes. Could it then be pending verification with pretrial if they can get in touch with the cousin?
State?
The only other issue is because it's a battery, I believe pretrial would need to be contacting the alleged victim also.
Okay. That's fine. So,
So I would just ask that the only condition not only be just that they contact or verify an address, but that they
No
speak to
objection.
the alleged
Okay.
victim also. In that situation, I have no objection.
all right, so the order will be to pretrial release with electronic monitor level 1 upon verification of a stable residence and upon no objection from the alleged victim. in
And
the
it's not
case.
even so much no objection from the alleged victim. I just want them to be able, they need to verify.
Well,
an-
they have a right to be heard, so at this point, at this
Okay.
stage, it would be no objection.
Okay.
If they do have an objection, I have no objection to bring it in front of the sign, either putting it back on, but then the victim would have an opportunity to be present to be heard. But at this point, it would be
Appreciate
with
that,
no
Judge.
objection from the victim.
No, for
Yes.
clarification purposes with the GPS, if his addresses are verified, he won't be going anywhere. So seeing that
Correct.
this is gonna be a GPS, it'll be pretrial release GPS level 1. I hope Hector is explaining to his client that that's total lockdown.
Correct.
He would not be able to go to work, do anything.
It doesn't work, so I don't think that that's an issue.
Come to court.
If and without objection from the court, should he find
it's not
employment, I'm
Of course,
considering
of course it's-
remodification.
I assumed it was without prejudice that we
Yes.
modified at a later date.
Correct.
What's pending?
Level 1. And we've already ordered no victim contact, correct?
Yeah, that was ordered.
Okay, that stays in place.
It's not pending. He's still in jail. He stays.
Then what's he being, but then what's he being held on?
Right, it's still 1,000, it's, right, he can always post the bond if he would,
No,
if he
that's
chose.
what,
Yeah.
All right, it should be that if he doesn't qualify for pretrial, then the bond stays at $1,000.
that's what I figured. That, yeah.
Or if he somehow can
Yes.
get in
Yes.
touch.
Pretrial, pending verification, release, GPS level 1, and no victim.
Right, and if that is unsuccessful, then the bond remains in place.
I know, but that's how the judge wants it to be done, so.
Yeah, because otherwise, then how are we gonna, what's it gonna be
No, no,
ROR
That was my
or?
concern, is
Yeah.
that he'd be essentially be held no bond, but they can't
Correct.
verify, which is unlawful. And
Thank you. All right, Delton Tompkins.
Conti?
How you doing, man?
I'm doing well, thank you for asking. Mr. Tompkins, you're here on a second look for the charge of petty theft. What was the original?
One moment, and the concern here, I believe Judge Fry raised his bond to $1,000. The reason being this, he was arrested August 24th for this theft. He was on probation for another theft.
Okay.
It looks like, or at a capias, it looks like the matter was resolved and he was released from custody for another theft July 18th.
Okay. All right, and it was set on the second look docket because he can't afford the $1,000?
Yes, I would imagine.
All right, well, what say you, defense?
I would ask the court to consider releasing him, Judge. It's a nonviolent misdemeanor charge.
Does he have a place to go?
Well, unfortunately, Judge, we get these second look dockets about the same
that time-
time that you, so
All
I
right,
don't really
Mr.
have a chance
Tompkins.
to talk to the individual.
Hi, this is Judge Levine. We were considering whether or not there's an alternative to you posting a $1,000 bond. My question to you is, if you were to be released, where would you go?
I have my mom.
The concern is, and I was just checking, going back a little further, on the probation he just resolved, when he initially got picked up the violation of probation, he actually was ROR'd on it. Then he failed to appear and got rearrested in June on the capias for failing to appear at his VOP for theft.
Is it filed yet? I mean,
Well, no, this case, he was just arrested last Thursday.
okay.
It doesn't
Do
seem
you
to.
work, Mr. Tompkins?
I work with my uncle, man.
Oh, family, all right. Well, at this time, I'm not inclined to change it. However, I have no objection if you can get family members to come in on your behalf and maybe your uncle to come in on your behalf to say that he's gonna keep an eye on you, give you employment, that your mom's willing to come in and say that, yeah, sure, you can live here without any problems. But today, I'm not inclined to do it. So today is denied.
Judge,
Yes.
it'd be best, cause I know she ain't gonna have no way in. It'd be best if you call. So I know my mom have no
Well,
problem.
all right, well, the public defender is on it. Good luck to you, sir. At this point, no change. I don't have to, yeah. I got nothing to sign, yeah. Okay, Anthony Pete.
Your Honor, this is a battery. I would ask, this one is very fact sensitive with the details. I don't know if you could, hopefully it's up on Odyssey. If not, we can get you a copy. And to advise the court, his bond was raised to $7,500 because of
I thought they weren't resetting the violent ones.
pursuant to the AO administrative order. Basically, all misdemeanors have been reset for second looks.
7, 8, 9, 7. Was that Judge Fry as well?
No, that was actually Judge Hurley, I believe, Friday afternoon. This case. Michelle, I sent it. You got it.
All right, I read the probable cause affidavit. And Judge Hurley set a bond at $7,500. What say you, defense?
No, Judge.
Okay.
I'm sorry. There was also looking over. I remember I did also go over his criminal history with Judge Hurley that he also took into consideration
Is it anything similar to these allegations?
to a degree.
What was the priors that might be reflective of that?
Oh, Your Honor, in 2001, it was a juvenile direct file. He had a lewd and lascivious in front of a child less than 16.
I don't think we need to go into a lot of detail,
Okay.
Judge. Our office is aware of Mr. Pete's situation.
All right, at this point, the court's not inclined to change the determination that's already been made. All right, Mr. Pete, the court's not making a change to your bond at this time. George Medrano?
Your Honor.
I'm sorry, where, Maine?
He's a Maine.
All right, we have operating without a valid and failing to register your vehicle.
Yeah, Your Honor, I don't know if you have his driving record there.
Thank
If
you.
memory serves, I believe he has a history of DUIs that
Is
Judge
this a DUI, a suspension on a not reinstated DUI, or?
I'm not sure. I don't really recall.
All right, I see a refusal in 2001, that's it. The refusal in 2015, but that would have expired, I think, by.
Yeah.
It's 18 months. So 16 plus 6, so it would be mid 16. This is a date of offense of 8. So yeah, so that would have expired.
And just to note also, and it is date, and I know this prior is dated. I only bring it up because it is quite an aggravating offense. In 1988, under the name Nastali Torres, he was convicted of murder in the second degree and robbery with a firearm or deadly weapon and sentenced to 12 years in state prison.
I don't know that it's relevant to his driving without a
No, I
license.
understand. I'm just bringing.
Yeah.
I
appreciate
can't
it.
make an assumption. I want to just make sure the court's aware. That's all.
Thank you. What say you, defense? What was the bond anyway?
$5,000.
It was $25.
You're asking what it was set at or what the convenience bond is?
Who, Judge Hurley?
Yeah, set it at 5,000.
And at that time, I think I probably said it, that was tantamount to no bond. And
All
I know
right,
he
what
probably
is your
said, "I understand."
recommendation? What is your
Judge,
recommendation?
I'd be asking you, Your Honor, to consider an ROR back to the convenience
Wow.
bond of $25.
Yeah.
He's
Let's-
50 years old.
Let's try something other than that in light of the fact that he doesn't have a license, never reinstated on the refusal, and hasn't obtaining a license by fraud. So why don't you try something in between 25 and Judge Hurley?
That's a lot of room.
Would you do then a combination of 25 plus pretrial? He lives with his wife, he's 50 years old, he's been living in the same residence for 22 years.
Yeah.
He would have, he would have initially bond out, but she didn't have the $25 to post his bond, so he had to appear in front of magistrate.
Does he work?
He does work, actually in the PCF.
Don't you?
Actually, in the PC affidavit.
Please tell me he wasn't on his way to work. Okay, I've heard that more than once. Okay. In light of his history, the court's inclined to place him on pretrial release with an EM monomer level 2 because I don't want him driving. No driving, Mr. Medrano. Do you understand?
Yes, ma'am. Yes,
I don't know how
ma'am.
you're gonna get to work, but the public system, bus system or bicycle, but you're not driving.
No, my driving partner left there.
Don't say anything else, sir.
I'm just telling you, you cannot drive, or you're not gonna like the consequences. All
Yes,
right.
ma'am.
EM level 2, no driving.
Depending on the kind of work, let him know he's gonna be confined to the Tri-County area.
Does he work outside the Tri-County area?
Let me inquire.
Only.
Broward County.
Perfect. All right, no problem. So ordered. Yes. All right, that takes care of that docket.
Actually, no, we have one more person from the second look docket.
No bond.
Mr.
I mean,
Luncheon
If
Moreau.
he doesn't have an no, just put him on pretrial, yeah.
Well,
All right.
he wasn't put, Mr. Moreau wasn't put on the docket.
Do we have anything? Because I don't have anything in
It's-
front of me.
What I can tell you is, it's a trespass and Mr. Moreau, let's see. And it wasn't, the allegations aren't just that he was somewhere where he wasn't supposed to be. He was, according to the probable cause affidavit, harassing customers. I can tell you, one moment, Judge, just this year alone, threats to specified individuals and trespass, violation of an injunction, failure to leave property upon order, disorderly intoxication and trespass. Last year, burglary, failure to leave property, trespass.
All right, sit down. What was the bond that was set?
I believe it was.
Right now, it's $1,000.
That's, Judge Levinson set that over the weekend.
Okay. And what say you, defense?
Judge, he is homeless, but he does have a mailing
Luchin
address.
Moreau.
He can get mail through his sister. He did advise me he's going to ATI. He's studying electricity, and this time, though, he's not working. He's asking Your Honor if you would. I was working with the guy. Judge, at this time, we'd be asking you to go ahead and consider an ROR or in the alternative pretrial, and he would go ahead and abide by reporting once a week to pretrial, Judge.
I understand that it's frustrating, but in light of his history, the court does not feel that he is a good candidate for pretrial and is going to leave the bond as is. Case number for the record?
Yeah, I can get that for you, Judge.
So,
The charge is just trespass. As far as the case number,
Judge, in the alternative, would you consider resolving the case? I know there's an owner, and I know from what you said before, the court would be reluctant if Mr. Lender could contact the owner and they had no objection. Would you consider resolving it, putting it on tomorrow?
is this a first or a second?
there's a reason he wasn't on the docket. He saw Judge Lungaren in our mental health division this morning.
Okay, so it's already assigned to division, so at this time, I'm not inclined.
Do you still, Tanya, do you need
Yes,
that?
Judge.
And I think that's a good place for him, and maybe she can address it. Maybe you can set it in front of her sooner rather than later.
Figured I should've checked from the beginning.
Judge, my
he
understanding
was on
is
the docket.
he's advised me his case was transferred out of learner rep.
Oh, I guess he did not want to be there or did not want to receive treatment.
I didn't understand what was going on.
Yeah. I'll give you a chance to talk to whoever was in there, but at this time, I'm not inclined to resolve it. Because I would not be inclined to do a time served sentence.
Yes, Judge.
Okay.
All right, so let's do the other docket. Quentin Adams.
Judge?
Yes?
Conti?
Paul Ryan has one from the second look.
Conti?
I thought we did everybody on second look. I didn't have anything left.
Last name is Marino.
Oh, the other
First name
docket.
is Alexander. No, this is the second look.
All right, I'm sorry. Let me go.
Paul Ryan.
I don't have a Marino.
This is Alexander Marino. He was also transferred to Judge Lorna Wren. She, in her mental health, he has seen her in there as well.
Oh, it's on the second docket, okay.
Okay, so I don't have that on, I don't have a docket with a Marino.
They took
They took it off?
him off because he
Okay,
was transferred to
so
Judge
because you
Lorna
already
Wren
saw your judge today, they did not put you on this docket. So
I
you,
didn't see the judge today.
they said,
I think he went, I believe he went yesterday
well,
and
maybe
she
it was
reset
yesterday.
it.
Did you
I
see
didn't
some?
see any judge.
All right, let me-
This is
All right,
first appearance.
well, yeah, you had your first appearance. This would be.
Okay, he was scheduled for a status conference before Judge Lorna Wren today. It was been reset for Thursday.
Oh, okay, you've been reset in front of Judge Lerner Wren for Thursday. That, you'll see Judge Wren on Thursday. He's free to go. Do you have anybody else at Paul Ryan?
Not for the second look, but I do have one female.
All right, pull her up, bring her up.
Kathleen, come on up. Last name
Kathleen Mitch,
Michelle.
Kathleen Michelle. Okay, what is this? This is a 30.
Yes, Your Honor, one moment. Yes, Your Honor, the state filed an information today, and merging this with another case that you already has pending.
Okay,
And
so
I'm sorry.
are you asking for additional?
No, I'm asking that, no, we filed the charges. I'm asking that the motion be denied. What we did was we just merged, she had another case with other charges that stem
And-
from this. We just merged these charges
Okay.
into that
And what,
case.
Peter, you satisfied that it was merged? I'm assuming.
If that's what Mr. Lender says.
Oh,
All right, do
that's
we
what
need the
happened.
case number of the merging, or?
Well, no, Your Honor, because I think it's proper to deny it on this case number. The jail's getting the paperwork and they'll make the appropriate,
Okay. In that case,
when they
denied.
receive the filing instructions.
All right,
Brian,
thank
let me
you.
give you the case number that it's under, 176995
That's-
CF10A.
Thank you.
And you'll see where it lists this case number as a companion case.
All right, perfect. Thank you. That's what
Or
I was looking for.
consolidated case, I'm
Appreciate it.
sorry.
All right, so we're done with Paul Ryan?
I believe so.
Thank you. All right, is there anybody at Conti?
Yes, ma'am, two?
Do you have Quentin Adams there?
Yes, stand right here.
Come on up. I'm doing well. Mr. Adams, you're here on us, to see
It's,
defense motion for ROR based on whether the charges?
we have not filed an information. Mr. Adams is entitled to release on these charges at this time.
Okay, so you'll be ROR'd on these charges. You'll be released
Oh, well, that's what I said on these
on
charges.
this charge.
Right here.
And Lunkinson Pofu?
Yes, ma'am, how you doing, Judge?
I'm doing very well, thank you for asking. You're also here to see whether or not charges have been filed?
We have not filed charges. We
At
have not
this
filed
t-
information on this case, Your Honor. He's entitled to ROR on these charges.
Okay, so at this time, you'll be released on your own reconnaissance on the pending charges. Good luck to you, sir.
You too, Judge.
Make sure you keep looking on the computer in case they do file.
Yes, ma'am.
Okay, good luck.
All right, thank you, Judge. All right, ma'am, that's it for coffee, thank you.
All right, do we have anything else that needs to be addressed? All right, we're off the record. Thank you, everybody.